rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Stewart versus Sterling Mobile Services, Inc., our case number CV130221. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you choose to do so. If you want to, make sure you keep track of your own time at the podium using the podium clock. Out of respect for counsel, I would ask those in attendance to make sure that your cell phones are off. Also, we have read the briefs and conferenced the case this morning. We would encourage you to keep that in mind as you present at oral argument. Also, our proceedings are being recorded and will later be posted on YouTube. So as you begin your argument, please state your name and the party that you represent. With that, let me start with Ms. Is it Mandio?
Manolio.
Manolio, I'm sorry. Please proceed.
Thank you. May it please the court. Good morning. My name is Veronica Manolio. I represent Sterling Mobile Services, the appellants in this case. And I am going to do my best to watch my clock because I would like to reserve time. However, I know I have a tendency to speak a lot and I know I have a tendency to answer a lot of questions. So I will do my best. This case, to me, couldn't be more indicative of why I don't do family law in any way, shape, or form. It's also indicative to me of how a commercial case just got into a separate context from a strict commercial matter or a civil matter. The issues that are presented, or the issue that is presented for me, is I think that there was an error of law in allowing an equitable remedy to go forward when there was an adequate remedy law that was found and was found to be untimely brought. The issue that I have raised, and raised multiple times at the trial court level, to the point where poor Judge Talamonte told me it was making him a little sick to his stomach, and I fully understood it, but wanted to make sure I made a very good record for the appeal, is that once you found that a contract existed, oral or otherwise, there is no longer an equitable remedy to fall back on for unjust enrichment. I understood entirely the entire time that my clients, and remember originally it was Sterling Mobile and Michael Jeffson that were sued. Michael Jeffson was immediately dismissed because everyone agreed he wasn't personally liable for anything. These two people were loaned money to start their company. Why these issues weren't addressed at the time that the folks divorced is beyond all of us. But at least one of the things that all courts agreed, both in the divorce and in this case, it wasn't an issue at this point. Both courts said, we are where we are. This debt is getting dealt with in this forum. Neither court would reopen or reconsider, and we are where we are. So in 2011, when Grandma and Mom and Dad come back and say, we want money from Sterling Mobile, they say we have a contract claim and we have an equitable claim. Judge Talamonte definitively says you have an oral contract, not evidence.
Where does he say that?
In his minute entry that is dated, and it's Exhibit B to my opening brief, that's dated in August. And he says, I find that this is an oral debt not evidenced in writing.
So debt means, in your view, contract?
Yes, and in fact, because that's exactly what the statute says under the oral debt, under 542. It tracks the statute verbatim for what we all call oral contract.
But my understanding is that the court concluded that contract, if you will, that agreement was insufficiently precise to constitute an enforceable contract. And lacked a critical term, which was when repayment was due.
And that is exactly and precisely what the oral contract statute does as versus an unjust enrichment statute. The oral contract statute specifically says an oral contract is when you don't have specificity as to terms, and the long list of cases say, then you have lack of specificity, payment is to commence on the date of the loan. That's the accrual date.
Well, that's the accrual date, but that's
the-
not when the loan is due. That's not when repayment, that's not when I can sue you for breach.
I agree with you.
Because clearly it's not due the day the loan is made.
That is correct. That's when your time starts to tick.
Right.
Then in this case, it got even better for Ms. Stewart because 3 years later, the wife, Kelly Jeffson, entered a note. Although we disputed it was authentic, it was held to be authentic, and it was then evidence of the oral note, the oral debt.
But there's no payment date in that note, is there?
Agreed.
Either, is there?
But it extended and gave another 3 years for which this person was on notice that she had a debt
Right.
that she could either seek to enforce or file suit on.
But the question we started with and that I'm struggling with is whether the court found a contract and an enforceable contract, and whether that would be as affirmed or not. I mean, my understanding is nowhere, orally or in writing, is there stated the important term of when payment is due.
2 places there are, actually. There is actually 3. There is the important term of when payment is due, because it says by statute, when you make an oral debt, you make a promise, it is presumed that your clock starts to tick, your statute of limitations starts to tick the day you make the loan. So you don't get the benefit of saying, well, I loaned money, but since I didn't give a payback term, I can wait forever and there will be no trigger until I make a demand. That's the whole reason that 542 exists and removes oral debt from an unjust enrichment scenario. It's the reason that it completely separates, because an unjust enrichment...
Okay, so that's one place. Where
That's one
are the
place.
2 other places where the term is stated?
The term is stated, if you read their statement of facts, the plaintiff's statement of facts, from day one, they wanted the benefit of a 6-year contract. They wanted a benefit of a contract in writing. So from the very first motion that I filed and said, this is outside of the statute of limitations, they filed sworn affidavit saying, this is a contract with sufficient terms of repayment, and they put forth the payment terms. They said, every term is specified, and
Counsel, let me ask
Sure.
you with that. Did your answer admit there was a contract, or did you deny there was a contract?
we admitted there was a contract. We admitted it was an oral contract.
You admitted there was an oral contract in your answer.
Yes, and we admitted there was an oral contract and admitted it was outside of the oral contract.
But denied there's a written contract.
Correct.
So the position you're talking about, you disagreed with.
Yeah, we've always denied that there was a
Right.
written contract.
And the trial court rejected that position as well, correct? Trial court found no written contract.
Correct.
Okay.
Yes,
Now,
he found an
I
oral debt.
interrupted you. There was a third point you were going to reference.
The third point was that Ms. Stewart herself testified, which is why I filed a motion for summary judgment on the accrual date and a motion for summary judgment or a motion for reconsideration when I was denied on the unjust enrichment claim, because she said, I believed payment was due within 1 year of the loan.
That was her trial testimony.
She said it prior to me in deposition as well,
Okay.
which is why I filed before trial and said, I know this is untimely, Judge, but why are we wasting resources on a trial when she unequivocally said, when I loaned that money, I anticipated it would be paid back within 1 year. Well, if that's her testimony and she's the person who loaned the money, we know her accrual date because she said she had expected it back in 1 year. And then she said it again at trial. So she reiterated her testimony, and that's why in my briefing I cited it both and said, she said it twice, Judge, and I understood completely this is an older woman, and so there were times she'd say a couple of different things, but unequivocally she told me, I expected it back within a year. So the reason I am saying there was a definitive date is because the record says there was. The reason I distinguish
Well, the
this.
trial court found there several dates, right, as a fact finder, and ultimately found one that was within the limitations period, whether it's a 3 or a 4 year. Isn't that fair? I'm not saying you agree with that, but I'm saying what happened.
Here's what the trial court did, which I don't think comports with any version of a statute of limitations finding. As a matter of fact, the judge said, we have testimony, and it's the court's own trial transcript. It's a trial transcript at page 30. The court said, we have testimony from the plaintiff herself, who said she knew in December of 2007 that her money was in trouble, knew it was in trouble, but she didn't ask for it. She said, I don't want to interfere, I don't want to do anything, I'm going to let it be. Then she could have known as late as 2010. So I'm going to say there's a continuum for accrual.
Right.
I've never read a case that says statute of limitations could be a continuum. It was a new
How
concept.
often is it tried, though? I mean, typically, it's addressed by motion as opposed to having the finder of fact, and you agree, don't you, that we owe deference to the factual findings of the finder of fact?
I do agree that we owe deference to the factual finder. I also agree that when you have a record like we had pre-trial, where the witness testifies pre-trial 2 times, I knew in December 2007, and I expected payment within 1 year, that was unopposed testimony. Nobody else said she was wrong. She's the person who loaned the money. That should have ended. It shouldn't have been another fact finding. That should have ended the inquiry at summary judgment phase.
You know, the problem that I'm having with this is with we're talking here about, or your argument concerns the accrual date of a claim for breach of contract or for a claim for unjust enrichment. But we don't have a definitive payment due date. We don't have anywhere written down where, or even stated when payment was due, and the other side of that coin is when a breach occurred or would occur for non-payment. And her testimony, as you say, I expected to be paid back within a year, but that doesn't tell me that he promised or Sterling promised to pay back within a year. That could fairly be read to mean a grandmother's hope that everything would come together and the company would succeed and she'd get repaid. So that doesn't tell me when non-payment would constitute a breach. So the premise of when the claim accrued to me is kind of wide open.
Well, but here's the problem. If you follow the law, Arizona law, and it is true, they had an oral agreement in 2004 when the money was loaned. And we know there was an oral agreement, and the statute says that's when your ticker starts to click. You have 3 years to do something. So you either, at the end of that 3-year period, need to make a demand for your payment, or you know you're going to lose the right to go after your payment. Why? Because Arizona will not let you sit around for 20 years before you ever make a demand.
Right.
And then say, I never knew we had a dispute.
And see, that's why possibly the trial court did not find there was an oral agreement. Because consistent with that notion is if you give someone money without specifying when they must repay it, it is not fair for you to wait 20 years and then say, hey, I need that money now.
But unfortunately, the trial court did find there was an oral debt. I mean, very specifically in writing in his minute entry, he said there was an oral debt. It was not repaid. However, the time has come and gone for that. He said it in his minute entry, which is Exhibit B, said it again in his minute entry, which is Exhibit C. And then at trial, he went on specifically to say that claim, those contract claims have come and gone. That's why I let her go forward on her unjust enrichment claim. because she lost the contract claim, and because she doesn't have a contract claim, she gets to proceed in equity. Well, the equitable claim is not when you get to proceed in equity because you lost your contract claim as untimely. It's when you didn't have a contract because you didn't have a meeting of the minds or you didn't have some other requisite
The only
element.
way to square that, given the presumption that trial courts know the law, is the trial court actually found that there was no binding contract, that to the extent plaintiff made contract claims in count one and let's set count two aside because I don't think that's really part of it, but that would be barred by limitations, but that didn't foreclose equity. In other words, there was no adequate remedy at law because those the 2-minute entries that the court decided or court issued in addressing your dispositive motion, they weren't one right after the other, but they're pretty close in time. And the parties had fully briefed all these arguments, and the thought that the trial court somehow then ignored the law and said, well, I actually find that there's a binding contract, but it's just time barred, but we'll still cut to equity. I mean, I don't see that in the record.
Well, I do, and respectfully I do. And
No,
and
I want you to help me understand
And
that.
here's why. Because you think about it in this context, the parents sued as well. And the parents had the exact same claim as Ms. Stewart. They had an agreement. They gave the kids money with no written contract, no payment terms. And he said, you had an agreement with no terms. It's too late. You don't have written terms for repayment. It's too late.
And I understand what you're telling me, although the issue before us has nothing to do with the parents.
But what I'm saying is, when you ask me, he presumably had to have said, well, it has to be some sort of an unjust enrichment. That wouldn't justify, that wouldn't make sense then, why he wouldn't have done that for the parents. They had the exact same set of circumstances. Both parties loaned money without parameters for payback, without writings, without anything at the time. Because remember, Ms. Stewart's writing didn't come until 3 years after the loan.
Mm-hmm.
So both parties loaned money on an oral, here's money for you guys to get your business started. On the parents' claim, he said definitively, yeah, that's an oral debt. You don't get to come back 6 years later and sue. Dismissed, went away. It was never asked to be reconsidered by the plaintiffs. It went away because the judge understood that was an oral contract. It went away.
Well,
And he
you're
never.
asking us, though, aren't you, to sort of look into the mind of the trial judge, and I guess with respect to what happened that's subject to appeal today, a way to square that is to understand that the trial court found there was no binding contract, but even if there had been, it was barred by limitations, but that still left equity as a potential remedy. Otherwise, he could not have denied the motion on equitable grounds, on count 3.
I'm not asking you to look into the mind of him. I think that's what he wrote. I think he made it clear because I moved to reconsider and said, Judge, you made a finding on the record that you found that count 1 was an oral debt. And because it's an oral debt, Judge, that means it's governed by 542.
Well, and to complete the story, he found that it was an acknowledgement of an oral debt not evidenced by a contract in writing, correct? I mean, that's the
Correct.
full sort of phrase.
Mm-hmm. Which is, under the statute, an oral debt. I mean, we can.
For accrual purposes.
Exactly.
This is a common law contract. There's no statutory provision describing what had to be in the contract.
Absolutely agreed. But what
Or
I
any
am saying
contract,
is, for purposes of accrual, he found, for purposes of accrual, I'm finding this is a accrual of a common law contract, and I'm even going to give her the benefit of doubt that there was a writing acknowledging it, which gave her an additional 3 years to sue. And he said, so under 542 and even under the savings statute, or under the 508, I'm giving her an additional 3 years. She had every ability.
You're not meaning 6 years on the writing, because
He-
if under 6 years under the writing, it was within the limitations period clearly.
No, he did not give her.
Okay.
No,
I didn't think you were saying that. I
No,
just
he
wanted
did
to
not
make
give
sure.
her a 6-year written contract. He did, however, say the money was loaned the money was loaned in 2004. It was then in 2007 that the note was written. And he said, I will even extend 3 years from that 2007 period. And he did. And even from that 2007 period, extending it 3 more years, she missed the statute of limitations because she didn't file until 2011.
Do you want to watch your clock?
So thank you. I appreciate that very much. I believe you don't have to look in Judge Talamonte's mind. I believe the record is clear. He made a ruling that there was a legal remedy, and then he also let her proceed on an equitable remedy, and it just can't be done by law. It turns Arizona law upside down.
Thank
And I'll
you,
reserve.
Counsel. Thank you.
Thank you.
Mr. Gianmarco.
May it please the court. Zach Gianmarco on behalf of plaintiff, appellee, Elizabeth Stewart. This is a valid unjust enrichment claim. The trial court never found an oral contract existed, so Stewart never had an adequate remedy at law. And in action,
What did the trial court find then?
the trial court found, and I'll look exactly at the trial court's ruling at trial, or the trial court's testimony. The trial court held there is not a specific contract governing the relationship between the parties because, and I'm quoting here, there is no consideration paid, no labor, no services, no materials, no product, no nothing, pardon the grammar, no nothing promised in exchange, no terms sufficient to support an oral contract, and no agreement on when this amount was to be repaid. So therefore, there's no oral contract. And looking back at the minute entry, that the trial court's under advisement ruling on Sterling's motion for summary judgment, which counsel referenced, the court revealed that the April 26, 2007 note was Sterling's acknowledgement of a debt. This is not the court finding that it's an oral contract or that even it's an oral debt. It's Sterling's acknowledgement that this is an oral debt. The trial court was not stating that an oral debt existed, but stating merely that Sterling acknowledged that the existence of an oral debt via the note, because Sterling was the one that signed it. And so there's a big difference between which way you interpret that. And
The parties acknowledged there was a debt, but the trial court didn't find that there was an oral debt?
correct. The parties, did you say the parties acknowledged there wasn't a debt or was a debt?
That there was a debt.
The parties, well, the parties acknowledged there was an impoverishment and an enrichment for this to fall under an unjust enrichment category. There was no agreement between the parties. There was no terms on when it was to be repaid. And
Counsel, let me ask you, though, and I understand the impoverishment and enrichment, but we only get there if we get to equity. And if your client had an adequate remedy at law, whether it was timely or not, we never get to equity. And I appreciate what you've shared about what Judge Talamonte found at trial, but that was trial on the unjust enrichment claim. And your adversary, as you know, is arguing that the trial court made findings that are squarely inconsistent with us ever getting to equity. What did the court find, or what could the court properly have found in addressing the dispositive motions that would allow you to have the trial at equity?
well, if looking back at the minute entry, again, it states the trial court's minute entry found the note to be Sterling's acknowledgement of an oral debt. That's not the trial court saying that this is an oral debt. It's Sterling's acknowledgement. It's additional evidence to be considered when determining the impoverishment and the enrichment from Stewart to Sterling.
Well, but again, and you're using equitable terms, and I understand that, but before you do that, you have to convince the court that there's no legal remedy here, quite apart from limitations, period. Is it your position that the trial court, in addressing the motions for summary judgment, found that there was no enforceable contract, assumed that there was an enforceable contract, and then applied the limitations period, or some other alternative that I have yet to think about?
Well, the trial court's minute entry, it's pretty clear that it's just stating that it's an acknowledgement of an oral debt, and that's Sterling's acknowledgement, not the trial court's acknowledgement. Then the trial court went on to allow the unjust enrichment claim to proceed, and that's because there's no enforceable consideration. Because Stewart was arguing from the beginning that this was a contract, as an alternative theory, that this was a contract, the note was a contract. The court said, no, this is not a contract, and therefore allowed, based on the lack of consideration, the lack of terms, and therefore allowed the unjust enrichment, the equitable claim to proceed.
And so an oral debt, what you're saying is different than a contract?
It is, and therefore it's not subject to the 3-year statute of limitation. If you look at all the cases that interpret 12-543, the oral debt 3-year statute of limitations statute, each case there holds an oral contract with enforceable consideration. The state of Musgrove, which is cited by counsel, the court found an oral contract was barred because it was beyond the 3-year statute of limitations. Freeman v. Wilson, Moore v. Diamond Dry Goods, the list goes on and on and on. Every case that interprets 12-543, it implies or it states that there's an oral contract to begin with. That statute, that cause of action accrual, the 3-year cause of action accrual, only applies for oral contracts. It doesn't apply to unjust enrichment. Instead, the court needs to look at Natrini v. Feinbaum, which is an appellate court case, I believe, and the court found that the cause of action in unjust enrichment claims first accrues upon the defendant's repudiation of the obligations.
And let me interrupt you and ask you to back up a little bit.
Sure.
You mentioned that 12-543 applies to oral contracts, and the trial court applied that to find that count 1 was time barred, and that's not been appealed. That's not in front of us. But my question again is, did the court first find there was a contract and then find it was time barred, or did the court assume that there was a contract but then find that any such claim would be time barred?
The court never found there was a contract. The court never held there was a contract.
So you would say a fair reading of the minute entry is, even if there was a contract, even if there were terms that would satisfy our definition of a contract, it was time barred. The claim would be time barred.
Correct.
And do you think it's fair for us in reviewing what the trial court did in the entire case to look at its comments, which you recited to us from the trial, to help us understand what the court meant in that minute entry when it talked about an oral debt being time barred? I
think so, because there's really nothing else to rely on. And the court went on at length discussing the cause of action and the contract accrual, because counsel for defendants continually raised the statute of limitations issue and the adequate remedy at law. Therefore, why should this unjust enrichment claim be brought before the court at trial? In fact, before trial, counsel even brought it up again. And so at that point, and it's interesting to note that the counsel stated today that Sterling never admitted that there was an oral contract, because their motion for summary judgment, or they admitted there was an oral contract from the beginning. Their motion for summary judgment and motion to dismiss both allege that that this was gift money, and there was no contract made between the parties, and therefore, there is no claim at all, whether that's unjust enrichment or contract claim at all.
Let me follow up on a couple of points, one that Judge Johnson just raised. The evidence at trial on the unjust enrichment claim differed with respect to a possible accrual date than what was in the court in addressing the motion for summary judgment, at least as I see the record. But did the evidence at trial differ on whether there was oral or written contract from what the court had in addressing the dispositive motions?
No.
Okay.
No, it did not.
And with respect to the gift, you allege, or you concede that this was, or I think the parties stipulated this was not a gift. Is that correct?
Correct.
Okay.
At trial.
Right. And there are a number of stipulations that, at least as I read the transcript, maybe
Correct.
15 or so that you started trial with.
Correct.
Okay.
But prior to that, Sterling and Sterling's counsel, via Sterling's counsel, alleged that this was gift money in a motion for summary judgment and in a motion to dismiss. So they were not saying this was an oral contract all along. They did not agree all along, and
Well-
they pled alternative theories as well.
I think it's fair to say that the parties' positions may have evolved in this case as the case went along. Would you agree with that?
I agree completely, and that's my argument. You're allowed to plead alternative theories pursuant to law. Rule 8E2 of the Arizona Rules of Civil Procedure allows a plaintiff to plead alternative or even
Believe me,
inconsistent.
for both counsel, I'm not, by making that observation, I'm not suggesting anything improper. I'm just, it's sort of, it depends on when a filing was made, where you were in the proceeding, the parties' positions. But in a simple world, it seems to me that when a stranger to a company, like Ms. Stewart, provides the company funds, in a simple world, it seems to me either it's a gift or it's a loan in the nature of a contract. Your position is a third option, I rather gather. Tell me more about what that third option is.
It's an unjust enrichment. It's an impoverishment and an enrichment. There's no consideration, there's no product, there's no services, there's no materials, there's nothing given, there's nothing promised between the parties as stated by Sterling's CEO.
If you give someone money without any terms, doesn't that kind of appear to be a gift?
Well, at trial, Sterling stipulated this was not a gift, this was a loan. So that argument's out the window as far as I'm concerned, because trial, it was no longer a gift. So,
That's
but
what Judge Thumma was talking about. I think everything changes depending on the
Correct.
time of at the point in the litigation.
correct. And so the question is whether the unjust enrichment claim was timely. If assuming the unjust enrichment claim was allowed to proceed and there's no adequate remedy at law. Once we get past that, the next question is whether, what statute of limitations applies and when does it accrue. And I believe counsel's in agreement. I haven't heard any controverting testimony that the 4-year statute of limitation applies as stated in ARS 12-550 and San Manuel Copper Corp. That applies in an unjust enrichment case. And then the repudiation rule applies as stated in Nitrini v. Feinbaum. That's when the cause of action accrues, when the defendant first repudiates the obligations. And
Counsel, let me ask you, under the trial court's finding, though, on the accrual date, and there is at least a whiff of a difference of opinion on whether a 3 or a 4-year period applies to unjust enrichment. We don't have to decide that, do we? I mean, if we get to that point, the trial court's accrual date was timely, whether it's a 3 or a 4-year period, correct?
Correct. That's my argument all along. The trial court chose to use a discovery rule, and even using the December 2007 date, which was the earliest date on the continuum raised by Judge Telemonti, the cause of action would still be valid and timely because it's within the 4-year statute of limitations set forth by San Manuel Copper Corp. So the bottom line is utilizing the repudiation or the discovery rule, Stewart's claim is timely. Okay. Now, as far as fees, looking at fees, Sterling disputes the fees, the attorney's fees awarded to Stewart, but utilizing any test, Stewart was clearly the prevailing party. In Drozda v. McComas, the court determined that a plaintiff is a prevailing party if he sues for money damages and recovers those money damages. Here, Stewart
Can
did
I ask-
exactly that.
I read the challenge to fees as indicating that because the unjust enrichment award was improper, the fee award should be vacated. Is there more to it than that?
Well, I was just adding that she's the prevailing party, and so if the unjust enrichment claim was proper, then obviously she should get fees. Her fees were cut in half. We didn't cross appeal on that. The court found that Sterling succeeded on some summary judgment claims, the breach of covenant of good faith and fair dealing, and the claims against the McIntoshes, but.
And those are not subject to this court. There's no cross appeal, anything like that, correct?
No, Your Honor. No, Your Honor. So as far as the court cutting it in half, the court already considered Sterling's partial success in that regard, and so the fee award should be upheld to Stewart. Because Stewart requested $55,000 and $30,000 in interest, about $86,000 total, and recovered $55,000. So she was 63% successful in this case. I don't know, in Sterling's reply, there's a mention that Stewart requested $110,000. I don't know where that number came from because that's not the figure listed at trial. So utilizing any test, the percentage of success test, the net judgment test, Stewart was the prevailing party. And again, going back to the unjust enrichment argument, the trial court never found an oral contract existed, so ARS 12-543 shouldn't apply. The 3-year statute of limitations shouldn't apply. Stewart didn't have an adequate remedy at law, therefore she's allowed to proceed. All the cases that counsel cites for the 3-year statute of limitations, those are oral contract cases. You need to step out of that and go to the unjust enrichment case, which is Natrini v. Feinbaum and San Manuel Copper Corp., which is the 4-year statute of limitations, and it doesn't accrue until it is repudiated. So based on that, Sterling admittedly first repudiated this obligation in 2010, making this claim extremely timely considering it was filed in 2011. And I believe the court should uphold the trial court's ruling on this matter, as well as the attorney's fee award given by Judge Talamonte to Stewart. Thank you.
Thank you, counsel. Ms. Maniolo, rebuttal.
Thank you. I know my time is brief. I have 3 very, very pointed issues I'd like you to consider. Number 1 is the minute entry that we all keep talking about. Judge Talamonte's minute entry on summary judgment is definitive, and it is not as plaintiff says. The August 29th minute entry does not just say this was a written acknowledgement of debt. Judge Talamonte ruled Michael Jeffson, on behalf of Sterling Mobile Services, that the note signed by Michael Jeffson on behalf of Sterling is an acknowledgement of an oral debt not evidenced by a contract in writing. The court further finds that plaintiff Stewart's cause of action accrued on the date of the note and is subject to the 3-year statute of limitation. He therefore found she had a cause of action under the oral debt. The complaint in this matter was filed June 28, 2011. For that reason, it is ordered granting summary judgment as to count 1. There's no mistake in the record. You don't have to get in his mind, and you certainly don't have to believe plaintiff's counsel that, oh, he just said it should be then unjust enrichment. The second point is...
Counsel, your time has expired. I appreciate that.
I apologize.
Thank you very much. Counsel, we appreciate your briefs. We appreciate your argument today. We will take this under advisement. We'll issue a written ruling in due course. We stand at recess on this case. We will stay on the bench while new counsel for our next oral argument make themselves at home. Please take your time all. We are here and we'll be ready when you are. So thank you.